Welcome to 5 Minute Family Law and the second of two episodes about the legal consequences of separation. In this episode, we're going to be talking about the impact the date of separation has on identifying and owning family property. In the next episode, we're going to talk about the emotional aspects of separation, including how to build and maintain healthy boundaries with your ex and how to make sure that your privacy and your ex's privacy are protected after separation. Now, you'll recall from a past episode that the basic way the division of property works in the family law context in British Columbia is this. You get to keep whatever you have going into a relationship. What you have to share are the things that you accumulate between the date the relationship begins and the date the relationship ends. The date the relationship begins is defined as the earlier of the date that you get married or the date that you began to live together. The date the relationship ends is defined as the date of separation. And so the date of separation is the date when you stop accumulating shareable family property and shareable family debt and begin to again accumulate property that is presumptively yours, which you are not assumed to have to share with your ex. And so you're probably beginning to get a sense of the importance of the date of separation. It's critical for determining what the family assets are. It can be important to determining their value, and it's important to determine how they are owned. So, Section 81 of the Family Law Act says this: on separation, each spouse has a right to an undivided half interest in all family property as a tenant in common and is equally responsible for family debt. That's a really important section, so let's dig into that in a little more detail. First, let's talk about being tenants in common. There are two ways that two or more people can own property in British Columbia. You either own that property as joint tenants or you own it as tenants in common. And there are some really important distinctions between those two ways that two or more people own property. As a joint tenant, each joint tenant owns 100% of the property. And that means that when they die, their ownership interest essentially evaporates because all of the other surviving owners continue to own 100% of all of the property. With tenants in common, on the other hand, each owner owns a defined slice of the asset. It might be a half interest, it might be a third, it might be 20%, it might be something else, doesn't really matter. But the important thing about owning a discrete slice of an asset is that when you die, your ownership interest goes to your estate. It doesn't get automatically absorbed by the surviving tenants in common. It's just yours, and it goes to just your estate. And so, what Section 81 says, and this is really important, it says that no matter how property was owned during a relationship, so for example, shareable family property might be owned just by you, just by your spouse. The two of you could own it together as joint tenants, or the two of you could own it together as tenants in common. It doesn't matter. On the date of separation, under Section 81, all of the property that qualifies as family property under the Family Law Act becomes owned equally as tenants in common. There are a lot of important implications that flow from how property is owned after the date of separation. First of all, it's important to know that even though you are, as a matter of law, a one-half owner of all of the family property as a tenant in common, the title to the family property hasn't actually been changed. However, your status as a tenant in common is enough to protect your interest in the family property from your ex's creditors or from your ex's decision to go bankrupt. However, in the event that your ex dies, your ex's share of the family property will go to your ex's estate rather than flowing to you, which it might have had you not separated. The other funny consequence about how property is owned after the date of separation is that a spouse who is the only person on the title to a particular piece of family property is now under an obligation called a fiduciary duty to protect the interest of the other spouse in that property. So say, for example, that you're the only person on title of the family home. Well, As a result of the separation, you know that your ex has an undivided one-half interest in the family home as a tenant in common. You have a fiduciary duty to avoid allowing anything to happen to the family home, such as damaging the family home, failing to maintain the family home, or selling the family home, that would have the effect of damaging or reducing your ex's interest in that property. And so, separation has a bunch of really important consequences. It's the date on which, no matter how property was owned during the relationship, anything that qualifies as family property is now owned by each spouse as tenants in common. These consequences can be terribly important, and as a result, it is especially critical that you get advice from a family law lawyer whenever you have questions about your interest or obligations with respect to family property.